Okay. Right. Good morning. Just welcome everybody to today's webinar, Manage the Present, Maximise the Future. It's going to be a practical discussion on how to deal with major events on construction projects. I'd like to thank Ankura and specifically Rob, Shane and David, who you'll all be hearing from and who are speaking today, for their help in organising this webinar and for preparing for this webinar very informative and also a lot of fun, but I'll let Rob make the jokes later. We have a wide range of attendees today coming from all parts of the construction industry, both in the UK and internationally, representing funders, employers, main contractors, developers, as well as professionals, subcontractors, so the whole gamut of the construction industry. And we all hope that you will find something of interest from today. Before we fully get going, I must do some housekeeping. My head of business development made a joke about telling you where the fire exits and so on are, but I'm not going to do that. So the real housekeeping is just to tell you that the webinar is going to last an hour or so. We're built in time for your questions at the end of the session. So if you have any questions, please use the Q&A function at the bottom of your screen to send the panel your questions, and we will try and answer as many as possible at the end. We've already received a number of questions. Thank you for those who sent them through, and we'll also try and address those as we work through. As Rob will explain in more detail, we will be running some polls during the course of today as well, which we hope will be informative for everyone. I will now hand over to Rob to introduce the speakers and guide you through this morning. Rob, over to you.
Thanks very much, Richard, and similarly welcome to everybody who's taken the time out to listen to this webinar live today. I want to start by introducing our panel today. It's an excellent lineup of speakers. You've already heard from Richard Bailey, who is a partner in the construction group of Goodman Derrick. As I'm sure many of you will know Richard, and will know that he's considerably experienced in resolving construction disputes here and in the UK and internationally. Richard has a long-standing connection with the Society of Construction Law, and in particular you might have remembered that Richard was the organiser of the SCL boat trip, so you might say that he is very well used to guiding people from the construction industry through choppy waters. That's probably about as bad as the jokes will get this morning. One of the most fascinating highlights, I think, of Richard's career, though, is that he once advised on the building of a green zone in Iraq, and in particular was asked to give advice on the challenge of moving rocket-proof cladding from Basra to Baghdad. Next on our panel is Kieran Farno, who is a senior associate at Goodman Derrick in the construction team, experienced in domestic and international disputes. He has a huge knowledge that spans most sectors that you would expect, including industrial, commercial, education, infrastructure, nuclear. One of Kieran's most impressive accolades, not many people can have this experience, is that he has experience before the Supreme Court. He's also a thoroughly down-to-earth person who, in his own words, is genuinely excited about scaffolding. So we'll look forward to hearing from Kieran later. Next is my colleague David Savage. David is a civil engineer and delay expert. David has worked on global projects in Europe, the Middle East and Asia, and David knows all about disruption, having started his career actually in a war zone in Iraq. And finally, my colleague Shane Nash also has first-hand experience of the construction industry. His first job was actually mixing mortar for a gang of block layers. And as a practical joke once, he was left suspended in midair while the teleporter operator went for lunch. Not quite sure why that came about, but nowadays Shane is actually a global quantum expert who has worked on cases in Europe, Africa, the Middle East and Asia. So that's our panel. Let's get things started. As Richard said, we are going to be running some polls this morning, and I thought we'd start with just the first of those. This is an interactive session. It's a chance for you to engage and tell us a little bit about your thoughts on the topic here this morning. So I'm going to launch the first poll. I'll ask everybody, please be honest. Please, please make a selection here. The first question is, thinking about project resilience in the face of disruption, how confident do you feel about your ability to monitor costs and track, prepare and pursue or defend claims? I'll give you a few seconds to make your selections. We can see some interesting votes coming through. It's good to see that not everybody feels totally confident that that they've got everything sorted. We've got about sort of 50 out of 70 odd who have voted, so around about sort of 70%. I might give this the 5-second rule, and I'm going to end the poll, and I'll just share these results. So they're very sort of interesting results, quite a mixed level of feeling there in terms of preparedness in the face of any type of disruption which you might sort of see on a construction project. But perhaps unsurprisingly, I think the majority of people feel that that they are reasonably well prepared, with some concerns under review. So, interpreting that differently, it seems like, that there may well be, other things that you could learn and things that you'd like to sort of address, gaps perhaps that need sort, looking at. So I think that those results really underscore the the point of our webinar this morning, and one thing we see is that the world is awash with unimaginable change. That type of change can be hugely disruptive when you're managing a construction project. So, Richard, if you maybe like to take yourself off mute, what do you think our audience should be thinking about from a legal perspective?
Thanks, Rob. Yes, well, I think I was going to start with saying what a year it's been. Not just the events that we've had culminating in the whole COVID-19 and related recession that we're now heading into. But if you go back a year, we were talking about a no-deal Brexit instead, which was also going to cause massive disruption to the construction industry, which is back on the cards now, and it's all at times like this. It's the contract that we look to, and with lawyers like myself and Kieran, we spend a load of time rewriting and worrying over the detail of those contracts. So we think, what happens? The first point always to make when thinking about contracts, they're a framework that govern the relationship between the parties. Now, those might be funding agreements, which contain specific condition precedents for drawdown requirements, that's the construction contracts, subcontracts, everything else, but they govern the relationship. And most of the time, apart from price and things, materials and so on, what we're really worried about when we're thinking about a contract is risk. And generally, it's pushing the risk down as far as we can down the chain. So contracts, I'm going to just briefly touch on this morning and how they address these issues. The JCT, which I'm going to talk about the Design and Build 2016 form, which is by far the most commonly used contract in the UK, which is used for sort of normal construction work, might say office buildings, warehouses, fit outs, developments of blocks of flats or whatever. The NEC form, well, as the name suggests, used for engineering projects of various degrees of scale. And finally, a few words on the FIDIC form, which not really used in the UK, but it's one of the more dominant forms of contract that's used around the world. But what all these contracts have in common is they are based on the norm, the expected, those events we would expect to happen as the many moving parts of a construction project go from start to finish. And while they have provisions designed to deal with everyday occurrences, changes in work, strikes, weather, actions of statutory authorities, they're always there. And there's one at the end though, which we always ignore, force majeure, or at least we did until about February, when suddenly force majeure became the most common ground for an extension time, because of course there was nothing else in the contract. If you asked me a year ago what force majeure was, I'd say it was a highly nebulous term that no one could really understand what it was. But there lurking, relevant event number 14 in clause 226 of Design and Build, for those who know it well, was force majeure. Now, that has become a complete, and we're going to inevitably have something happen in court soon where it's an interpretation of whether it's a force majeure or whatever. There was, of course, the other one that hid in the JCT, actions of the government after the base date. But it's even hard to understand what that means, and the government did their best not to actually do anything apart from tell us construction was open, but we should work from home. But how you work from home when you're building a building, I'm not quite sure. But someone who regularly reviews and drafts contracts, there's a number of different approaches to it. But COVID has appeared, or now as a force majeure event, and some say base date. The NEC, on the other hand, looks at it as a compensation event, and it's built in their core clause 6. Clear system for applying for and dealing with compensation events, to deal with prices in the chain, changes in price, completion date, key dates, all to do with the project manager, all bound up in the contract. And all contracts will have procedures for dealing with compensating contractors with disruption, other contractual methods, acceleration, which we will come on to later on in today's discussion. They don't always have an exact fit for the new problems that we have. So we have to provide, and force majeure as being the fallback, the sort of catch-all. There are cases where you always thought someone running a force majeure argument was just, you have nothing else. You really are a loss. Now people are having to use it as a sort of first stop because of what's happened. But the real issue is how we're going to go forward and how we're going to deal with inevitable additional costs. And that's when we start to look at the topics that we're going to move into. So it's just briefly on there. NEC is a globally used contract, has choice of law clause, alternative dispute resolution, dispute boards. But the king of all the international contracts, if I'm allowed to use that terminology, is a FIDIC form, where the engineers fundamentals to the smooth running of the project. Force majeure, there's a specific force majeure clause, far more important. It's clause 19.4 of one of the forms. Force majeure clause, of course, on major international projects, you have dispute boards, and sometimes standing, sometimes ad hoc versions of dispute boards. And those things that work through this dispute. So as I've now started to talk about FIDIC, it's appropriate time, I think, to hand over to Shane.
Thanks, Richard. Just a couple of comments on FIDIC, and I suppose drawing from my own experiences, working in the Middle East, North Africa, etc. I think, for those of us who have worked in the Middle East, I think it's fair to say that often contracts badged as FIDIC standard forms can be anything but, particularly in respect of the way that risk is managed and shared between the employer and the contractor. And oftentimes it's modified to the extent that, it completely negates the original intent and spirit of its original unamended form. And arguably, contractors can employers take advantage of perhaps very competitive market conditions, or perhaps even the naivety of contractors in some instances. And perhaps there's an entirely separate discussion to be had on the extent to which this actually negatively impacts employers. In terms of attracting top-tier international contractors to the Middle East and North African regions. However, this doesn't get away from the fact that contractors willingly enter into these contracts, which can be very, very onerous in terms of, risk distribution, not really appreciating how deep the water into which they are wading really is. So therefore, I would say that it's most unwise to assume that any contract badged as a standard form, particularly internationally, we see as with FIDIC, that any of the terms or any contract is even generally reflective of its original unamended terms. There could be many onerous changes within the special conditions, particularly with regard to risk allocation, even notifications, payment terms, design responsibilities, etc. So just to conclude, I suppose, and it is I suppose, an obvious issue perhaps, and it's at the risk of stating something very obvious. I think it's hugely important that contractors, and indeed all parties from the get-go, become, you know, intimately familiar with the terms and conditions within each individual contract. Thanks, Rob.
Thanks very much for that, Shane. And so we're right, you know, I think that we can't really speak about disruption on this webinar without mentioning the COVID-19 situation. Kieran, what specific impacts around the coronavirus have you been thinking about?
Well, I've been giving it a lot of thought, and I've even prepared some slides. Thank you for bringing those up. So in terms of where we're at with coronavirus, it's helpful to look at what statutes have come to pass in the past 3 months. And I've just tried to list there the 3 main pieces of legislation insofar as it relates to England. I just note that in Wales, for example, there are more strict restrictions on business. But the main point to bring out from this slide is that the health protection coronavirus restrictions mandated the closure of specific businesses where there were premises. However, construction typically is undertaken outdoors, and so there weren't any restrictions in relation to that. And I suppose what I have to remember in relation to this piece of legislation is that the reason I have this much hair is because barbers have been closed for 3 months, and I'm very much looking forward to that piece of legislation being amended. What that means for you in terms of construction operations is that your performance in continuing to build things won't be illegal, and it therefore means that your contract can't be discharged by virtue of 2 English law doctrines. One is the doctrine of frustration, and the other is the doctrine of supervening illegality. And just in relation to illegality, there's case 150 years old, which quite helpfully illustrates the approach the English courts takes, and that's War v Morris, which related to a charter party which was for the loading of cargo from France to London. And at that specific time, there was restrictions on landing boats. But in that case, the relevant judge, Blackburn, found that performance was still possible because you could unload the cargo from alongside another boat. So you didn't actually have to land the boat to affect performance. And that would basically be the way that courts would look at construction, as in there are things which I'll turn to in a moment that make construction more difficult, but it is still possible in the vast majority of cases. If we can move on to the next slide. I just wanted here to highlight what your health and safety duties are. So there's 2 main pieces of legislation. The first is the primary legislation, the Health and Safety at Work Act 1974. And the bit to bring out here is that you're required as an employer to ensure the health and safety of your employees, but also those who may be affected by it. So it could be people in and around the site or whatever it may be. And in terms of what this obligation is, it's not an absolute obligation. People still can have accidents and similar things on a site, but if you've basically done what is reasonably practicable, then you will not be found liable. Moving on to the next slide, we'll brush over this quite quickly. So I expect you're all very much aware of your duties. But what I wanted to bring out is just that everyone within the supply chain, including the employer, does have duties with regard to CDM. So on the client side, they need to ensure that the principal contractor, whether it's themselves or someone that they've appointed, need to comply with their duties. The principal contractor needs to update and review the construction phase plan, and equally any subcontractors or contractors who aren't the principal contractor, they also need to plan, manage and monitor their works. And I say all of that to say this, which is that you just cannot abrogate responsibility in relation to health and safety. It's not right or legally right for you as an employer to say, well, I don't care about your health and safety obligations, because you also will have them under CDM. Moving forward again, in terms of specific guidance in relation to coronavirus. So the Construction Leadership Council has issued a number of versions of a site operating procedure, which is effectively intended to provide guidance in relation to social distancing on construction sites. It's not legally binding in a strict sense, but in the same way that codes of practice under health and safety legislation can be binding, there's a case, Baker and Quantum Clothing, where Lord Mance said that a code of practice is an appropriate standard for a prudent employer to conduct his business. And so while the site operating procedure, which I've just touched on, isn't strictly legally binding, failing to observe it may give rise to difficulties in relation to your health and safety obligations. In terms of close work, well, firstly, there's quite a prescriptive list of things that should be done or taken into account on a site. I think David will touch on those in a moment, but the main issue, I suppose, is close working, and the guidance is listed on the slide. So where 2 meters can't be followed in relation to a particular activity, serious consideration needs to be given whether that activity needs to continue. And then if it is necessary, it doesn't say what you need to consider to determine that, but if it is necessary, then you need to risk assess that activity using a hierarchy of controls. And you can see there's 5 here: eliminate, reduce, isolate, control, and PPE. And I'll just run through those quickly. So in terms of eliminate, the intention is to eliminate, well, not kill, but to prevent people who come to site who may ordinarily have an illness. You'd want to eliminate the use of stairs. Sorry, you want to eliminate the use of lifts and hoists in preference to stairs, and to also consider alternative or mechanical aids to prevent multiple labourers being on the site. In terms of reduction, the idea is to minimise the frequency and time that workers spend within 2 meters of each other, and where possible to get them to work side by side rather than face to face. Isolate suggests that you keep groups in small teams, you don't change those teams, and you isolate them from other workers. Control basically means that you should have a system in place to monitor compliance with the regulations. And finally, PPE just means that where you can't observe the 2 meter distancing, you should wear respiratory protective equipment, i.e. face masks and potentially gloves, but I suspect they should be worn in any event. Thanks.
So just build. Thank you very much, Kieran. I just wanted to give a flavour of some of the physical changes that you might be seeing on your construction sites at the moment, given all of those changes in the regulatory landscape. So firstly, regarding the movement of workers on site, I think there've been quite a few changes as Kieran's alluded to, particularly on congested sites, but potentially city centre sites, that kind of thing. So you'll probably see queuing more on construction sites, typically following the 2 meter taped lines with access ways sort of drawn out. Although will it stay a 2 meter rule? Time will tell. One-way access routes will be more common now, I think. Additional sanitary facilities will be placed around the sites, and potentially this will further limit available working area and movement area. Numbers of people in certain areas are likely to be limited, such as hoists and lifts. You know, if they're still allowed, if they have to use hoists and lifts, there might not be stairs constructed yet. And there's going to be extensive signage to communicate all of these rules to the workforce. On procurement, I think there's been quite a few issues with procurement during this pandemic. Problems getting materials onto sites. Hopefully this is now improving now, but I think there are likely to be some changes to supply chains, and additional controls might have also been made as well. And in addition, you might see working shift patterns being staggered, temperature check cameras being installed around the site, as well as all your PPE, of course. And I've even heard of social distancing wristbands being used that buzz when you go within 2 meters of someone else on site. I think that gives you a little idea of some of the practicalities. So just moving on, I think once these more immediate measures have been implemented, contractors are likely to turn their focus to how and when are they going to deliver the rest of this project. So I think there needs to be a planning exercise fairly quickly, where typically contractors or subcontractors will have to go through each activity within their plan to see if these issues will have any impact. Will construction methodology need to change? Do work fronts need to change? Are there alternative ways of working to avoid close contacts, for example? Activity durations may need to increase, and new constraints may need to be added and considered. Opportunities should also be considered to mitigate delay to key milestones through changing the sequence of activities. And then after that, contractors should be in a position to predict the delay impacts on those key milestones, including completion. And that can enable those conversations to start with employers on the likely impact. And employers are going to be very keen to understand this and discuss this. Avoiding those big surprises down the line often helps avoid disputes, which is in everyone's interest. And these conversations might also lead to an early extension of time award, which would help reduce uncertainty, particularly for the contractors. Shane, did you have any views on the cost implications?
Yeah, certainly. Thanks, David. I think, I would view, from a quantum perspective, I would view the COVID-19 situation as really no different to any other, I suppose, unexpected event that occurs on a construction site that leads to loss and expense to the contractor, and indeed implications to the employer also. And, whilst, it can be very obvious that there may be considerable loss and expense flowing from such event, the routes to recovery aren't always so certainly immediately obvious, and they very much hinge on legal and contractual arguments. So what I would say, initially, the most important thing from certainly a contractor's perspective, in terms of contemplating potential claims down the line, is to immediately put in place if they're not already in place, very robust mechanisms for capturing the important data on site, particularly in relation to the capture of labor and plant resource, and also the work product that labor and plant resource is completing on a work front by work front basis across the entire project. And I suppose it could be said of any project, an initial investment, a relatively small investment to ensure that there's a resource or an individual that's responsible for collating that key data in relation to labor, plant, and other resource perhaps, and the work completed, the work product completed. It can pay huge dividends at the end when it comes to compiling and negotiating a disruption claim. I've been involved on some major disruption claims, either at claims or arbitration, over the years. A couple of particular ones that come to mind involve large metro systems, where essentially your construction sites practically spans an entire city, and where, delay and disruptive events are almost as certain as death and taxes, to be frank. Now, it never ceases to surprise me the extent to which some contractors and subcontractors, fail to put in place sufficient measures to capture, data which will inevitably, certainly be needed, in terms of trying to recover losses that arise on those projects. So just to conclude on that point, on the issue of records, I just want to mention a very well-known quotation from the late internationally renowned, and Irish, I might add, international construction lawyer Max Abrahamson, when he said, "A party to dispute, particularly if there is arbitration, will learn three lessons, often too late: the importance of records, the importance of records, and the importance of records." Thanks, Rob.
Brilliant. Thank you so much for that, Shane. Richard, could we perhaps hear from you, on the legal side of this discussion?
Yes. Thanks, Rob. Yes, we're dealing with records, yes, and more records, preferably. Inevitably, unfortunately, those records are not going to be great, and They also sometimes end up with arguments over whose records are the accurate records, who hasn't argued about the content of a set of minutes of meetings at some stage in their career. But yes, I mean, risk pricing acceleration, I'm going to break it into two parts really. Risk, because risk is, I would say risk starts at the very outset of any contract when you're starting to look at these kind of issues. The greatest and most common risk is cost overrun if you're the employer, especially when you've got funding, where that funding might be running out as a result of the cost overrun. You could even be on the edge of breach of condition precedents, additional interest charges, that kind of thing. But if you're the contractor, then you've got your own issues. You're worried about cost overruns yourself. You are looking at your subcontractors. You are looking at everything and seeing that there's money flowing out and you're perhaps not being paid yourself. So there's all that, and you're looking at those risks. And of course, if you're a lawyer, like myself, and you're drafting a contract, you have that minor moment of schizophrenia when you decide which client it is that you're acting for. If you're acting for the employer, all the risk must go to the contractor. If you're acting for the contractor, all the risk must go to the employer. And as long as you don't confuse yourself at any stage, you're going to get the contract your client wants drafted up. But those are the kind of issues that I always see around. But I want to talk about the acceleration point, because I think that's the big legal one as well, about risk allocation, which is looking at how the contract's being drafted. Because acceleration, for me, is one of the key things that we have to look at. And it's something, and maybe it's my age, but I can remember when we were always arguing about constructive acceleration on JCT contracts, because JCT never recognised the idea that you could possibly be asked to accelerate the works. And then you would have the shadow boxing of trying to get an employer to put it in writing they want you to go faster, when they would refuse to put it in writing because that would give you something you needed, and so you'd be fucked around. Thankfully, modern contracts do actually deal with acceleration. Obviously, there are practical issues, which other speakers have spoken about, because when you've got say 2 meters away from somebody, you can't load a site in the way you might once have done. But all of the contracts are now starting to address issues of acceleration to differing degrees. Well, I've talked about JCT, NEC, and FITS. I'll cover all three quickly. JCT is the most backward of the lot. It does now, in the 2016, have an optional extra acceleration quotation provision. However, it's buried right at the back in part 2 of schedule 2. It's not an integral part of the contract, although thankfully they now actually say, if you want acceleration, if you do not tick the box, then it is part of the contract. So whereas the NEC actually has express provisions baked into the contract, which deals with accelerations. It's core clause 3. So it's regarding acceleration. That's all tied into compensation events. When you're considering compensation events in the NEC, one of the things you really always do is consider whether things can be accelerated. But that's helped by the fact that the programme being so fundamental to the NEC, you should be seeing the problems arise, and you can see where the issues are, and you can see where you're at. JCT doesn't quite have that reliance upon the programme. That part. On FIDIC, they actually do have their own clauses built into on variations, where the engineer can instruct variations rather than. So all of them have now provisions that allow us to deal with acceleration and risk and pricing of it all. But when you've got a situation such as we have now with COVID, there's immense disruption. That's disruptions to the supply chain. And at the moment with supply chain, because of the international nature of everything that we do and where things come from, you never know now, because COVID is popping up in various different countries where you might have needed to source materials from. I had one client who was on a job where they all thought it was going to be months late because of COVID, and then suddenly the materials came available and they did everything in a week. So that was a fantastic achievement, but no one knew what we had. So you've got all this disruption and the contractual issues that it creates, because you've got to look at disruption. See, as I always tell my clients, just because you're entitled to an extension of time does not mean you're entitled to loss and expense. But ironically, you might not be entitled to an extension of time, but maybe you've been disrupted and there's a claim to put together. So there are things there, but it's considerable additional, and you've just got to get those records, because if you do not have the records, the cost information, everything recorded in it, as much detail as possible, more common in NEC and so on, for having that information, you're going to have it. But really where we are now, and this is the main thrust about the whole managing the present but maximising the future topic, is we're moving into a different phase now. And it's the part we all knew it was an extension time for force majeure, whatever. But as the dust is beginning to settle, we are increasingly seeing the cost of all of this. Not just the dreadful human cost that there has been, but the costs to business. They try to keep construction open. The City of London traffic wardens disappeared so that contractors could start driving to work, so they don't, and avoiding the congestion charge and everything else to get started. But it's massively affects productivity. And it's now that we have to have those records ready, because we're starting to see the truly disastrous impact that has had on business. Rob.
Richard, thank you so much for that. And while you've been speaking, we've had a few questions come in. I know we're going to generally save questions till the end. But there is one rather brief question, which I thought, is pertinent to what you've just been saying about records. And the question is, how binding are meeting minutes? Can they be relied on, for example, of giving notice or early warning, etc.?
Yeah, well, I have this conversation so many times. In fact, I remember drafting a contract where we were talking about this very point, and the way the contract was redrafted was to expressly say that minutes of meeting were notices, but the meeting had to take place within the defined contract period for giving notification. And it's become all the more important because the notification has to be given in writing. Quite often in amended contracts, you've got a condition precedent that you have to deal with. So it's really, I wouldn't rely upon meeting minutes. If you're relying upon meeting minutes, you haven't served your notices, which means you've probably got a problem. You might get away with it, but a notice would be a darn sight better. I wouldn't trust everything to a minute of meeting, especially, so you're the contractor, you didn't write those minutes.
That's very well answered. Thank you very much for that, Richard. So, so moving on then, I mean, so, clearly at this point in the sequence, the claims are coming, and that is, typically when you might think about engaging lawyers. So, Kieran, I wondered if we can turn to you and just hear a bit about what you might, as a lawyer, what are you thinking about when you're advising clients on the preparation of claims?
Yeah, thanks, Rob. So in terms of the preparation of claims, I find it's always helpful to get across to the client what they actually need to prove. So in terms of claims for delay and disruption, you need to prove things as a matter of fact, which in civil courts means on the balance of probabilities, which in plain English means more likely than not. So you don't need to prove something beyond all reasonable doubt, as you would in the criminal context. In terms of how you demonstrate the claim, there are three components to it. So the first needs to be an occurrence or an event which entitles you to be compensated. So under the NEC forms of contract, that would be a compensation event, and under the JCT forms, a relevant event or matter. The second part then is to demonstrate causation between the compensatable event and the delay and disruption that's experienced. And then finally, you need to show causal link between the delay and then some loss, which in some cases can be easy to demonstrate, but as we'll see, in others, it isn't. In terms of then what the court wants to see when you're proving something on the balance of probabilities, there's a helpful quote from Lord Justice Lloyd in McAlpine, Humber Oak and McDermott, where he noted that theoretical calculations, formulae and rules of thumb do not provide proof of anything. And what is needed is hard facts, visible and proved, in order to substantiate a claim for reimbursement. So that, I suppose, sheds some light, but what I find is even more helpful is to look at the often cited case of Waterlily and McKay, and in the context of global and total cost claims. And so the reason for mentioning that is because that is, I suppose, the opposite of taking a forensic approach of showing cause and effect between particular events and their consequences. And what Waterlily shows is that while it is possible as a matter of legal theory to make a claim for a global claim or total costs, the very nature of the claim means it's very susceptible to challenge. So in effect, it's basically saying that a number of events happened which are too difficult for me to actually particularize, but all of them are definitely not my responsibility, which is all well and good until you go through a court process and it is shown that one of the causes of delay is your responsibility. And in a sense, it's like building a house of cards. If one component of it falls away, then the whole claim can fall to nothing. So that's that. And then I suppose the last thing I wanted to comment on is records, and in the context of court or adjudication, what weight is to be given to what documents. And so I suppose the simple point I want to bring out is that contemporaneous records are far more valuable in court than, let's say, letters or witness statements that have been drafted several months after the event. And a way to illustrate this is a photograph, assuming it hasn't been photoshopped, is incontrovertible evidence of what something looked like at a point in time. Equally, labour resource allocation sheets, presuming they've been signed off, will provide a fairly accurate representation of who was on the site doing what at any particular time. And that would have to be compared with, for example, a delicately drafted lawyer's letter or a 30-page witness statement, which is prepared 6 months after the event, and when the parties' interests are obviously conflicting. And so it's going to be taken with a pinch of salt by any court or adjudicator. And then finally, before I pass on to my colleagues, is just in relation to notices. So some of you will be aware, either from the contracts that you're giving out or the ones that you're signing, that very often there will be time bars or conditions precedent to your entitlement to time and money. And I suppose all I want to say here is, while there is a trend of the court showing leniency in construing those provisions, you can't be helped if you haven't put in a piece of paper. So in a sense, going back to Richard's point on minutes of meetings, it's obviously not ideal to not have that piece of paper that's been sent by email or registered post, but as a supposed last resort, you can point to that minute of meeting and argue it's a notice. And that's, I suppose, me saying there may well be things that you can rely on to protect you, but what you should actually be focusing on is, what does the clause say you need to do? Do you have systems in place to ensure you comply with those requirements? And then I suppose this is more of a practical point, is just because you've given notice once doesn't mean you should stop giving further and better particulars, because I suppose from my perspective, if you're saying things contemporaneously, then they're more likely to be believed than if you're storing up those arguments for several months down the line. And I'll pass on to Rob again. Thanks.
Thanks very much, Kieran. So, I mean, just keeping an eye on the time, you know, David, perhaps in say, you know, sort of one minute or so, you know, what would you say good claims are founded on from your perspective?
Thanks, Rob. Yeah, sure. So I think good delay claims, at least, are certainly founded on primarily critical path analyses, and those are the methods of analysis that equate the critical delays on the project, and they have to be logical and transparent, and they don't necessarily need to be overly complex. Actually, breaking down its simplicity is very important. And well evidenced cause and effect, or causation, as Kieran's mentioned, is really important and is often the most challenging. and that's about the linkage between cause and the cause of delay and the effects of those delays on the site. Now, how would you evidence those through records? I think the cause of delay, you might be able to use things like the government guidance changes or the or risk assessments with mitigation strategies that have been agreed with the parties, or correspondence between the parties regarding agreed suspensions, things like that. But the effect side of things is often the most challenging and the most varied in terms of the information that you can capture, and it would. Essentially what you need to do is to be able to tell the story based on detailed contemporaneous records. And those records could be production records showing amounts of actual work completed daily, if possible, or perhaps weekly, or some other, hopefully small measure of time. Periodic reports, daily records, daily diaries, progress photos, as Kieran's mentioned. Inspection records are great to show when things actually completed and when they're accepted by the other side. Programs can be good, but assuming that they've been accurately updated, which is not always the case. And then actual resource data, timesheets, procurement records showing when things were signed off as they came onto site, things like that. But there are so many different types of record which can be used. But anything that tells a story, really. Thanks, Rob.
Thank you very much. Shane, just really quickly, I just wondered if you could maybe give us a couple of examples of evidence that you would need to robustly, value the claims.
Sure, yeah, and, very briefly, I suppose the three claims that will flow from unexpected events typically are acceleration, disruption, and delay. And again, I would like to re-echo what both Kieran and David have already said about the link between and the 5 prerequisites to a very robust claim. I always like to see our liability, entitlement, cause, effect, and then the valuation, which follows at the end. In terms of the mode of valuation, although all are very different, generally speaking, they're all predicated on the actual loss incurred to the contractor. So it shouldn't be a notional amount. It should be very much rooted in actual costs, where possible, linking those back to the project accounting records, and which are auditable, in the event of I suppose a dispute arising. It's very important to have your the same with any other records. Cost records should be anchored in very robust and accurate records. Just very briefly, and in terms of disruption, the most favored means of valuing disruption is the measured mile. As Kieran said, total cost claims or global claims should be avoided if at all possible. The measured mile really depends on very robust records. So it's absolutely crucial, again, as I think all of our speakers have mentioned, the importance of those records. Delay, by comparison, is relatively easy to value. It's simply starting from the project accounting records, stripping out all obvious non-time related costs, I find is the best way to value delay, because it means that you avoid the possibility of forgetting about certain costs. I think you should always start with the big picture. It also leads to a very auditable route through your costs, because they lead back to the project accounting records. Acceleration, just very finally and very briefly, can be done on a prospective or retrospective basis, depending on the provisions within the contract or the agreement that's put in place with the employer. Prospective valuations in principle, and again, depending on the contract provisions, can include elements of not just cost, but also margins for gross profit or even bonus amounts, depending on the extent to which acceleration is achieved. And retrospective valuations are essentially predicated on, after the fact, the contractor evidencing its actual costs over and above what it would have incurred had the acceleration not taken place. And again, they should be rooted back to the project accounting records. So that in very succinctly, Rob, kind of summarizes, I suppose, my main thoughts.
Super, thank you so much for that, Shane. I'm going to launch another poll now, just to, as we touch on the last topic, which is all about innovation. We wanted to hear from you, our audience. Which of the following innovations do you think will be most important in the next 12 to 24 months? And on this one, you can choose as many of the options that there are on the screen. And you know, in the interest of time, once we're able to sort of share the results, you know, we'll you know, perhaps invite each of our four speakers, you know, to pick out perhaps their favourite one of those and just sort of talk a little bit around that. So we're about 25%, 30% of the way through the voting. I'm going to give it another sort of 10 seconds or so, just so that we can get you know, a decent number of votes in there. And that's it. So I'm just going to share these results. And so overwhelmingly, you know, we see a high score there in offsite fabrication. You know, Richard, you know, perhaps would you like to sort of, you know, comment on perhaps one of those innovations?
Yeah, ironically, or perhaps fortuitously, I was going to speak on this section about offsite fabrication. And I can see, apart from software that increases productivity, offsite fabrication, it's not new though, that's the thing. I don't, maybe anecdotal story from when I was a trainee solicitor, but in the first few days and weeks of living as a trainee solicitor, I had to live in a very lovely flat, which had a pod bathroom in it, which was a plastic box with a sink and a shower in it, which was an old-fashioned version of the pod bathrooms, which are now incredible things that are fabricated off-site and shipped to press, and they look amazing with all the tiling done on their plug and play. That sort of off-site fabrication, I think, is going to become more popular, but it does come with its risks. It's actually about over 10 years ago that I was involved in the first contract I was discussing about off-site fabrication. And it was where a budget hotel, to be fair, it was budget, was being constructed in a series of sea containers. And I think it was in China, and they were constructing there. It was the entire room, the bed, the cupboards, everything was in there, including the bathroom, tiled, and it just came along, you plugged it in, and it was like Meccano. They stacked them all on top of one another, clad the outside, opened it up. There was even a window built in to these things. They're amazing off-site fabrication. It was great, but the problem was 80% of the cost was incurred before they got to site. And our normal contracts only talk about paying you when you're on site, and vesting certificates and that kind of thing just don't work. It's something Kieran and I have been involved in a few times over the last year or two. It's where you're having to set up these arrangements for escrow accounts and everything else to deal with these very high costs. So off-site fabrication, amazing. It increases productivity. It's a factory. The quality you can control far more, but you do risk it falling off the side of a ship on its way there and washing up on Poole Beach or somewhere. But it's amazing, but it creates its own problems with costs and so on.
Brilliant, thank you very much. Maybe just, you know, David, could you maybe just comment on one of yours? And I should just sort of say that I'm quite keen that we get to the questions fairly soon as well. So if we can maybe just you know, just hear other comments on innovation, you know, brief comments really.
I'll try and be brief, Rob. I think that productivity is a key thing that we'll be seeing more of in the coming months and years. I think in a world with more disruption, productivity is going to be very important. So I'm quite pleased to see software that increases productivity second on the list. But also it's not just about increasing productivity. I think it's increasing transparency of productivity as well, so that employers and main contractors have really good visibility of what's going on. And that brings in some of the other technologies like drones and augmented reality, perhaps BIM, so that you know, employers can see when things are slipping and they can intervene when necessary. And that's how that is supposed to work. So that's about all I need to say on that.
Okay. Kieran, do you have anything to add?
I was just going to add in relation to the off-site manufacture that they can often give rise to new problems that you may not experience presently. And going back to the anecdote, Richard's anecdote, we've recently been involved with off-site fabrication being done in China, and they were affected by coronavirus a lot sooner than we were, obvious reasons. And in that case, it meant that, sorry, in that transaction, it meant that things were really delayed for a significant time, and obviously not something that perhaps would have been happening if it was cast in situ or if it would have been done in the UK. So there are obviously different other factors that need to be considered if you are fabricating off-site, especially if it's in another jurisdiction.
Brilliant, yeah. Shane, anything to add? I see that one of our participants actually sort of said collaboration. I don't know if you've got any comments on that.
Yeah, I think that's an excellent point, actually. I mean, and I think, look, at standard forms are constantly, I suppose, morphing into better and better, you know, forms, you know, which take into account, you know, developments as and when they impact the construction industry. And I think collaboration is a very good point. I mean, ultimately, you know, it's all about risk and how risk is managed and how, you know, the employer on a long-term basis, I use employer in a general term, you know, gets the best return for its investment, and how contractors, you know, should be within relative certainty, you know, if they perform, they should be compensated adequately. And really that's about sharing the risk on a long-term basis. And I think collaborative approach, certainly in principle, if they can be, you know, converted into words, you know, in the form of contract, I think it's a very, very, you know, it's going to come more and more to the fore, I think.
Brilliant. Thank you very much for that. So I think what I'm going to do now is you know, I wanted to kind of allow some time for questions. You know, we've had, I want to say, first of all, thank you to everybody for sending questions live and also in advance of the webinar. It's very much appreciated. We won't have time to get through all of these, but you know, if we can maybe spend sort of 5 minutes or so just to walk through a few of these. One of the most interesting ones that came up, perhaps thought-provoking, and I'll direct this towards you, Kieran, was that the governmental response to the virus has varied dramatically from country to country. What should the contractor do where public health is endangered by government policy, and especially in the case where the employer itself is, you know, maybe the government or its agency?
Thanks. So I'm assuming that this question is based on an English law contract, because otherwise we wouldn't be qualified to give an opinion. But the point here is that wherever you're doing construction operations, and again, subject to what the contract says as to governing law, if it does say, for example, English law, governing law, it would still mean that you are subject to the relevant local laws in the country that you're building. So an illustration of India, you may have an English law contract, but you still need to observe their health and safety legislation. And in terms of the comment that you may be creating public health dangers, I think it's important to note that there's no real consensus about what measures need to be taken in response to coronavirus. We've obviously got a particular view here in the UK. It's clear from anyone that watches the news that that isn't an approach that's been taken across the board. And so it would be wrong to say that because English health and safety standards say this, that we must not do it in that way. And I suppose the final point is, if the works aren't suspended in your jurisdiction, then you will be under an obligation to proceed. And then it's really a question of weighing up the risks of the health and safety to your employees and those that may be affected by it, but also the risks of the financial consequences of a long-term suspension or termination. And so there's unfortunately no clear answer one way or the other, but you will need to assess what you can actually do in that country, and then what relief you'll be able to have under the contract.
Brilliant. Another really interesting question, and I'll direct this to you, Richard. Does the panel feel that contractors clients, etc., are now trending towards alternative dispute resolution as opposed to the courts to resolve disputes. What are you seeing?
I think it's too early to say, because I'm not sure that it's changing much. In fact, I have read in the press that there's a large number of disputes brewing. I certainly know there are quite a few in the background. I think that it's going to be a few more months before it really starts to hit, because at the moment we're in the early days, people stop work, but they're going to be coming back to sites. There's going to be encouragement to get people back. It's going to be harder to get to sites because other people may be going to their offices. Just as sort of anecdotal story, close to the office where Kieran is sat right now. By the way, you shouldn't be in the office, Kieran. He's working from home. You know, most of the roads outside, until the congestion charge was brought back, were just full of cars, and it was contractors working on building sites. So I think in a few months' time, there'll be more. Will ADR? I think depends how much money there is in the system. If money comes into the system to support businesses and so on, ADR makes sense. If not, we might be having a lot of people going back to their banks and saying, old style, I'm fighting this piece of litigation in arbitration or court. I'm going to win. Support me until I get out of it. So it very much, I think, depends on what happens.
Brilliant. I think one more question, which I'll direct to Shane, because you mentioned the measured mile as being an effective way to value disruption. Can you just maybe explain a bit more about what the measured mile is and how it's useful?
Sure, yeah, I will, Rob, yeah. I suppose it's straightforward and to some extent, and it's complicated. It involves very robust records to begin with. And essentially what you're doing from a valuation perspective, from a quantum perspective, is you're comparing the cost that a contractor incurs for work completed during a non-disrupted period of time to a period of time within which the contractor has been disrupted. And essentially you're trying to establish the extra over cost incurred during the disrupted period of time. Now, I think what's absolutely crucial, you know, when considering disruption and, you know, applying the measured mile principle, is to always be cognizant of the importance of linking cause and effect, so that really within the measured mile, you need to be measuring a period of time for which the employer is fully culpable. And if you don't manage to disentangle joint culpability within certain periods of time, you're going to struggle and you're going to end up with what's more of a global claim. But to answer your question, in principle, you know, it's to some extent, it's how long is a piece of string, but in principle, it's comparing two periods, an undisrupted period of time and a period of time, and the extra over costs suffered within the period of time, which you hang on the employer's responsibilities under the contract.
Brilliant. Thank you so much, Shane. I think we've kind of covered all of the topics that we wanted to on the, at least on the main body of the webinar. So I'll just hand back to Richard to wrap up.
Thanks, Rob. Yes, just a couple of comments from me to say thank you to everybody who's attended. Thank you to the individual who sent me an email in the middle of one of my talks, distracted me. You know who you are. Unfortunately, they can't answer back during this. Thank you to everybody who's there. Thanks to Rob. The only thing I really feel has been missed out by everybody is doing all of the Teams and Zoom calls that we had. Rob had a beard and he had two guitars in the background. And instead, he's gone for the Elvis look. Clean shaven, but you can't see the guitars. That's just, Shane and David now will be ribbing him for ages about this, I'm sure. But no, thank you all for coming. There's information available. There are some slides. You know, we will be following up. For those who haven't been able to see it all, I believe we have made a recording of it, so we will distribute that, which you can also share with anybody that you might wish to. I'm not sure. I think at one stage we were going to put it on YouTube, but I doubt it's had many hits if it is on YouTube. So thank you all for coming and have a good afternoon. Thank you very much.